The biggest mistake that parents make in child custody cases and how to avoid them. Most custody cases don't go sideways because a parent didn't care. They go sideways because of the small mistakes people didn't realize mattered. Hi, I'm Lindsay Egan, owner and founder of Poppy Pickle Group. I help people across Massachusetts navigate child custody issues when emotions are high and the stakes feel personal. And today, I want to walk through some of the biggest mistakes I see in custody cases and what parents can do instead. If this kind of insight is helpful, follow along. A lot of what I share comes directly from what I see parents struggle with in real, actual cases. So, treating custody like a battle to be won, this is the biggest one. Parents walk into custody cases thinking in terms of winning and losing. Who looks better? Who messed up more? Who deserves custody? Courts are not looking for a winner. They are looking for stability, consistency, and what supports that child's daily life. When parents frame everything as a fight, it often works against them. Speaking badly about the other parent, not a good look. This one surprises people. Talking badly about the other parent, especially in front of the child or in court-related settings, can damage your credibility super fast. Here is the direct answer. Judges are generally very good at telling the difference between fact-based concerns and emotional shit talking. Legitimate complaints are specific, documented, and tied to the child's safety or well-being. Shit talking is vague, repetitive, emotionally loaded, and focused on character instead of conduct. When parents raise concerns like missed exchanges, substance use, or unsafe behavior, and back them up with records, courts listen. When complaints simply sound like venting, exaggeration, or just scorekeeping, courts discount them and fast. Courts are watching for judgment. A parent who can't speak neutrally about the other parent often looks like a future conflict risk. Ignoring the importance of communication. Courts take communication super seriously. That doesn't mean parents have to be best buds. Probably not going to happen. It does mean, though, that they show that they can exchange the necessary information and make decisions jointly without constant escalation. Here's the practical answer. Once attorneys are involved, most direct communication happens through counsel, especially in high conflict cases. But courts still care deeply about whether parents can communicate at a basic level when attorneys are not present, right? We're always not going to be there. Things like scheduling, school issues, medical decisions, and emergencies. If one parent refuses all communication or turns every interaction into a crisis, courts see that as a long-term co-parenting problem. Even if lawyers are doing most of the talking, judges are thinking ahead. They know attorneys will not be there for the next 10 years, letting emotions drive decisions. Custody cases are emotional. That's normal. But decisions driven purely by frustration, anger, or fear often backfire. Courts focus on long-term stability. Calm, thoughtful choices carry more weight than reactive ones. Not following existing court orders. Another common mistake is just ignoring the current order while waiting for things to change. That's called self-help. They don't like that. We don't do that. Courts are expecting existing orders to be followed unless or until they are modified or changed. Even if an order feels unfair or outdated, not following it, at least in the interim, can hurt your position, assuming the court knows your full story. Judges don't know your history unless it's clearly and cleanly presented. They do not piece together context from frustration, long narratives, or emotional reactions. They rely on their records. Here's the specific answer to what matters. Useful record keeping includes details and dates of missed parenting time or exchanges, written communication that shows or displays cooperation or conversely, the lack thereof, school, medical, or child care records tied to your involvement, calendars showing actual parenting schedules, and documented concerns tied to the child, not adult grievances. What should someone start doing before hiring me? Keep neutral, factual notes. Save texts and emails and other written communication. Track patterns, not just those one-off bad days. We all have them. This is about helping the court understand reality without forcing them to dig for it. So most custody cases are not lost because a parent didn't care. They're affected by avoidable mistakes and misunderstandings. Knowing what not to do can be just as important as knowing what to do. If you're navigating a custody issue and want help avoiding these common missteps, you can book a consult online. I'd love to talk to you. We'll walk through your situation calmly, answer your questions honestly, and focus on what makes sense for you and your family.